Hi, everybody. I am so excited to be welcoming Jacqueline Gerrald from the firm of McLaughlin Stern to this session of Raising the Barre. And I think Jackie and I decided to call this You Got the Offer, Now What?, which I love as a title. Welcome, welcome, Jackie.
Hi, thank you. I'm so excited to be here today.
So tell us about you, how you came to be a partner at McLaughlin Stern, your background generally, and your interest in employment law.
Sure. So I went to Fordham University School of Law. I worked at a number of law firms before I joined McLaughlin and Stern. Started off at the firm as an associate, worked my way up to partner, and I'm now also co-chair of the firm's employment law department. I'm licensed in New York, New Jersey, and DC, but my office where I practice is located in New York City.
And McLaughlin Stern is a global firm, right? Or across the country?
Across the country. We're not international yet, but yes, we have offices New York, New Jersey, Connecticut, New Jersey, I mentioned, in Florida.
And so one of the things that interested me about you so much, one of the reasons I really wanted to talk to you is mostly folks are just employer side or employee side. You do both, which I think gives you some unique insights. Can you talk a little bit about what your practice involves and who you represent?
Sure. So my practice involves the employment relationship. Well, let me just go back. I do litigation generally, but my practice has been focused in employment law. So I do handle other matters that are not employment related. Okay. But in terms of the employment context, I represent, as you mentioned, both employers and employees, anyone junior up into the executives and directors of a company. I represent both sides. So when I'm negotiating employment agreements, I could represent the employee in terms of getting more favorable terms, compensation, et cetera. I also represent the employer in terms of drafting the employment agreement, negotiating it with an employee. And up to the point of termination, I'm also involved in that process as well. So when the employment relationship ends, I draft severance agreements for terminated employees. And a severance agreement is a separation letter that provides what happens when the employment ends, what type of compensation that employee may receive, what obligations that employee has to the employer when the employment ends, and what the employer expects from the employee.
Okay, so it's kind of like both. It's like the life cycle of like from the first moment from hire or negotiations, pre-hiring, all the way through severance and termination.
Right. And to emulate my colleague, Lauren Kramer, in her presentation about not-for-profits, she mentions that she is involved in the process from the birth of the not-for-profit corporation to its death. I go beyond death. I'm in the afterlife, things that happen after the employment relationship ends.
I love it. I love it, which hopefully is like heavenly and wonderful, right? If they follow your advice. Let's talk a little bit about the context in which you practice. So we all know that women are paid less than men. I think it hasn't budged much in the last 20 years. It's about 82, 83 cents. And I think I mentioned to you in the dance world, if you can get the job at all as artistic director, you're going to be making 63, 69, 70 cents on the dollar. On the administrative side, executive director, it's much more equal. And then just to confirm, laws do apply to not-for-profits, right?
Absolutely. The discrimination laws that are out there, whether it's on the federal level or the state and local level, cover both public and private employees. So it covers not-for-profit organizations as well. Yes.
Because sometimes they act like the law doesn't apply to them, which we can talk about a little bit later. And we've got different layers of requirements, regulations, et cetera. Can you explain a little bit about federal law? And then we're going to focus on New York. I know you're licensed in other states, but your practice is mostly focused on New York, which has been in the forefront of introducing and then passing transparency and other really useful legislation.
Right. So on the federal level, I mean, you have Title VII, which protects against discrimination on various grounds, including gender. You have the Equal Pay Act, which is another federal statute that specifically deals with wage discrimination. And then on the state level, you have New York State human rights law and the New York City human rights law are the state and local legislation that protect employees against discrimination in employment. But then there are also specific salary-related laws that have been recently passed on the state and city level. For example, in January of 2020, New York enacted the salary history ban, which prevents employers from asking prospective or current employees about their salary history and compensation. And not only must they not ask prospective employees about their salary history, they can't seek that information elsewhere. So they can't go to that employee's prior employer or look, for information online to determine what that employee is earning.
And can you explain a little bit why that's so important to women and candidates of color, for example?
Absolutely. So the purpose behind it is because women traditionally have been earning less than men. And when they start out in the employment process and they're asked about their salary, the salary that they provide will likely be lower than the men. And so than their male counterparts, I should say. And so when they start off with the application process, they're already at a disadvantage because they're already starting off at a lower level if the employer wants to match or just go a little above what their prior salary was.
And so that gets locked in and has obviously compounded, compounded interest and it goes up through an employment career and it ends up being hundreds of thousands of dollars, if not millions. Let's talk about what we're going to talk about today, which is it's not just about salary, right?
Absolutely. It's not just about salary. Compensation has different levels. So you have the base salary, which is what you earn, base compensation. Then there are other enhancements such as bonuses, whether it's a sign-on bonus that an employee gets when they sign on with the company, or if it's travel or relocation expenses that the employer covers for the employee to move from where they're currently residing to join the city in which the company is located to work. There could be holiday bonuses. There could be maybe even commissions based upon, for example, sales or revenue, what you contribute.
Or bringing in that huge gift if you're a development director.
Correct. And then there are other forms of benefits, which would be, for example, health insurance coverage, whether or not that includes dental.
Okay, so we've got health insurance, which most people do think about, dental, which I certainly hadn't thought about, membership at fitness centers, right?
Right, and childcare, for example, childcare, daycare subsidy or benefits. That would be another form of compensation that women may be interested in trying to negotiate with their prospective employer.
And then sabbaticals, right?
Correct.
Yeah, and going off and doing research work, et cetera. So we hear over and over again, both from men and from women, and we hear from the applicant side and then artistic directors, be they male or female, that women just tend not to negotiate, that they're scared and, the offers don't come around that much. And so they're very afraid to negotiate, find out what they're worth. I assume you've always been perfect about this?
Absolutely not. I can tell you, I can give you stories about the first employment that I received and the second employment. Whatever I was told they would give me as a salary, that is what I accepted. I didn't think that I could even ask for more. I felt that the employer had the advantage. I'm the prospective employee, and I had to take what was given to me. I didn't know that there was the option to negotiate and ask for more, especially based on what I felt.
Which makes me feel better, and I think so many other people out there. You do this for a living, and it took you a while to build up the courage. And we know from the research that it is very much a double-edged sword for women. I think it's Harvard Kennedy School of Government or the business school that looked at women who negotiate for what they think they should, be paid. And it's perceived very differently than it is if a man is aggressive in pursuing a robust compensation package. So I think women sense that, and it's a little bit of a tightrope. But one of the options, obviously, is to have an attorney or somebody else do the negotiation for you, or an agent, et cetera. When is the right time to bring somebody in? And do they do the negotiation directly? Can you talk a little bit about how that might work?
So I would say from the time you get that written offer letter or written employment agreement, you should definitely have an attorney involved to, at the very least, look at the agreement, mark up the agreement, and whether you want to present it directly to your employer or have your attorney do that is within the employees or the prospective employees' discretion, but you have to take into consideration whether or not it will create hostility with your future new employer. What I've done with my clients for the most part is if a prospective employee receives an employment agreement, presents it to me, I'd mark it up and give it to the prospective employee to present to that employer and to negotiate those terms behind the scenes. So I would be behind the scenes. This way, the prospective employee is not deemed as a troublemaker, before the employment relationship even begins.
Yeah, and I've heard it different ways, but somebody being out front, like, I just don't want to negotiate with them directly. I'm going to turn it over to so and so. But it sounds like the key thing is to bring experienced counsel in early.
Absolutely. Bring experienced counsel in early, because this determines what the course of your employment relationship is going to be with that employer. Once you've signed it, it becomes difficult to change it. You have to renegotiate again, and you'll be at a disadvantage once you've already started working there. If you do decide to have an attorney review it, which an employee is very free to do, then find out from the employer, maybe negotiate whether you can get that fee covered. Sometimes you may have an employer that is open to you having an attorney look at it. Find out whether they'll cover the fees for you to have the attorney review and negotiate that agreement.
Never would have occurred to me. Are there other documents that people should be looking at, like non-disclosure, non-compete kind of things that they might be asked to sign? I don't know if it's permissible to ask to see the employee handbook. What should somebody say? I think I'm going to be delighted to join you, but I would like to really know what I'm getting into, right?
Right. So they should ask about, when they get the employment agreement, they should definitely review the terms, what is expected in terms of when the employment relationship ends. Will this employee get compensation when their employment terminates? How that compensation will be determined? What would be the grounds for disqualification for such compensation? What is the employer expecting that employee to do once the employment relationship ends? Are you going to be prohibited from working for a competing company, or are you going to be prohibited from opening up your own company that's going to compete with your prior employer? Maybe there might be a continuation of the relationship. The employer may decide that it wants to continue retaining you, and you can enter into some form of a consulting agreement with the employer. So you may want to ask about those questions ahead of time.
Yeah, and I think that's a great point. We're not just talking about the for-profit world here. Somebody might have been an artistic director and decide that they want to go on and freelance choreograph. You still have a relationship there, and there's questions about, is your work in the repertoire? How do you handle that? You got to where I was going, which is, it is a relationship, and it's like you're hired in, it's the honeymoon, but at some point things may end. When is the right time to talk about that? Whether it's a mutual parting of the ways, or you've decided, I'm going to go off and write the great American novel, or, I just want to devote myself to choreography, or there's a termination. When is the right time to discuss that? And what's the smart way to sort of put it into the contract if you do?
You can possibly start with that conversation at the very beginning, especially if you're given an employment agreement. Have a provision in there about what happens when your employment ends in terms of severance. What payments would you get for continuation of your salary for a period of time when your employment ends? Will you have continuation of your health insurance coverage paid for by your employer is something you may want to discuss at the very beginning, because when it's at the end of the relationship, unless the employer has a policy, severance policy, or a severance plan in place or practice, they're not obligated under New York law to give you severance. And so unless you have some claims that you could possibly bring against an employer, which I've done before, then you can negotiate some kind of separation package or settlement amount of your claims. You probably would have a harder time having that conversation at the end of the relationship. If you can bring it up in the beginning, that would be a good time to bring it up.
And I know we talked about this, when we were chatting this past weekend. I think it bears repeating because people are frazzled and freaked out. And, I've had friends in this situation. We're very high level executives and very sophisticated. You're called into somebody's office. They tell you they're eliminating the position or there's been a management change. And by the way, that happens, it seems to me, in some ways more as you get more senior, not less, right? So, sees a new CEO comes in, he or she's going to change. There'll be a changing of the guard. And you might be asked to sign something there and then. You might be pressured, you need to sign this before you leave the building. What do you do?
You shouldn't be pressured to sign something right away. And you should have an opportunity to have, in the case of a severance agreement, reviewed with an attorney. New York, the federal law provides that for individuals over the age of 40, they must be given a time period to have claims of age discrimination. If they want to waive such claims, they must have 21 days to do so if it's a single employee termination. If you have two or more employees that are terminated, then you would have 45 days to consider whether you want to waive claims of age discrimination. And in return, the employer will pay you some sum of money.
Very often you're brought into an office, it's a complete shock. How am I going to make my rent? What's going through your mind? And I don't like it. But I've seen it over and over again. You need to sign this piece of paper right now, right? This is the best deal you're going to get, or we can't leave, you have to leave everything and walk out of the building, et cetera. This is your best chance. Are there laws? What do you do?
You should be given time to consider signing such an agreement, because that agreement is going to be asking you to release claims that you may have against the employer. That agreement is going to be asking you to make certain commitments. If the individual is under the age of 40, they're not entitled under law to a certain time period to sign such an agreement. But the law steps in when you have an individual who's terminated over the age of 40, who's being asked to sign an agreement that will require them to release any claims that they may have of age discrimination. So the Age Discrimination and Employment Act provides that employees who are over the age of 40 must have a certain time period to consider whether or not they want to release such claims and sign such an agreement. I counsel my clients who are employers that even if you don't have an employee who's over the age of 40, you may still want to give them a certain number of days, 21 days perhaps, because this way it shows that they've had a reasonable time to consider whether or not they wanted to sign that agreement and release those claims. And in the case of if you have 2 or more employees who are being terminated as part of a group termination, Age Discrimination and Employment Act provides that that employee should have 45 days to consider whether or not to release such claims and sign such a severance agreement. And so at least 21 days would be, I think, recommended. You're not required to if they're under 40, but it would be the better practice.
I'm fascinated. And again, I think this is where it's interesting that you've been on both sides, because having seen it from both sides, you're telling the employers, look, you don't want to be sued and told, and allegations of coercion, et cetera. Let people have some time to think it through. I also didn't realize that age discrimination, at least in New York for this purpose, starts at age 40. And I bet you most people don't as well.
It's a federal law. The federal law is over 40. State and local laws have different age numbers in terms of age discrimination.
Okay. So that's really great to know, because I think most people, hit 40, they don't think of themselves as old. You mentioned one really important point that I wanted to highlight, because we have a lot of single women, we have a lot of moms. You can ask for a continuation of health benefits, which I would imagine if you have a high-risk condition, if you're retiring because you're injured, if you've got children you need to take care of, that becomes very important.
Yes, because it becomes very expensive once you have that ongoing cost to pay each month for health insurance coverage. So that's additional compensation that you would like to get, once your employment has been terminated, before you secure other employment and get another employer to cover your costs. You would want to negotiate some kind of agreement so that the employer will continue to pay its share, or perhaps the whole amount of the health insurance coverage on a monthly basis for a period of time.
Yeah. And I bet when you're working with your clients, you monetize that for them. Here's what we're talking about in terms of what it will cost you. And in some cases, it's just less expensive for the employer to do it because they've got a larger number of employees they're trying to insure versus you going out and trying to find it on your own.
Right, because the employees, when, for example, an employee is presented with a separation package and it says that the employee is going to provide 3 months of continued salary, but the employee still has the out-of-pocket expense of paying for health insurance for 3 months, which can be quite significant if you add up the numbers. That additional benefit is additional money in that employee's pocket.
Before we sort of talk about strategy and there is an asymmetrical power relationship, obviously, in the ballet and the dance world and performing arts generally, I wanted to talk about some of the other things that you might be asked to sign, and just so that people start to get familiar with the terms. It sounds terrifying. Negotiate restrictive covenants. Can you talk a little bit more about what those are and why it's important? And in some cases, non-disclosure agreements, DDP has everybody in the team sign them, not for nefarious purposes, but because we want to be able to have a completely honest and robust discussion of projects that we're thinking about. So it's not always, I think, a bad thing or there's bad intent there. Can you talk a little bit about that?
Sure. So the types of restrictive covenants would be, for example, a confidentiality or proprietary agreement where the employee agrees to maintain certain confidential information of the employer or trade secret information, to keep that information confidential, not disclose it to outside third parties once their employment, well, not only during their employment, but that obligation continues after their employment ends. That's one type of restrictive covenant that an employee would likely be asked to sign while they're working at the employer, as well as after their employment ends. Other types of restrictive covenants, one that I mentioned earlier, is the non-compete, where the employer is asking the employee to agree for a period of time not to work for a competing company or not to set up his or her own business to compete with that employer. The Federal Trade Commission recently proposed legislation to actually ban non-compete. So that's something that's being considered. Wow. And there is a public review comment period, which was actually supposed to expire today, March 20th, but has been extended to April 19th to prevent employers from being able to have employees sign such agreements. And then you have the issue of non-solicitation, preventing the employee from soliciting employees or clients or customers of the organization. So these are types of restrictive covenants that you can negotiate with the employer. If I have an employee that presents me with such an agreement, for example, a non-compete, I would look at the duration. Is it for a significant number of years or is it for a short period of time? What's the geographical scope? Are they going beyond, the little area where they have their business, or are they covering the whole, country, all 50 states? So you look at it to determine whether or not it's reasonable. And these are things that you can negotiate with the employer at the time of hire.
And we say employer-employee, but very often, for example, when you're bringing in a choreographer, they're an independent contractor. And so I would imagine the same kind of negotiation can go on there.
Right.
Yeah. So the reality is, there's, it's a very female, as we discussed, it's a very female sector, dance, ballet, etc. Performing arts generally is a little bit more male, but dance in particular is very, very female. I'm constantly stunned, though, at how little information there is out there about pay transparency. We've talked about together the role of unions and what happens if you're covered by a union or not. And maybe we can touch on that again. But Can you talk about what women can do to find out more, like what they should be paid, what the going rate is, some ideas there? Because to me, knowledge is going to be power, right?
Yeah. So when I started to talk earlier about city and state local laws that deal specifically with salary, one other law that was recently enacted in New York City is the salary transparency law, which provides that for any job postings or advertisements for a position, whether it's at the time of hire or for promotion or a transfer, that the employer must now post a salary range. So that gives women an idea as to what they should expect to be paid when they apply for a position. Women can speak with their colleagues, others in the industry, possibly men, not just other women.
I was going to say, you made a great point when we were talking earlier that you should check in with the guys if they'll talk to you about how much it's how much they're getting paid.
Right. Not everyone is, willing to state what they earn, but if they are, they can find it out. There is a lot of information on the internet that you can find out when you look online in terms of certain companies. Some employees are posting information online about salary and what they're getting paid or should be getting paid. And there are also, in terms of not-for-profits, tax form 990s, which provide for information about they provide data for nonprofit organizations. There are annual tax returns that have to be filed, and to provide information about expenses and salaries that are paid to certain key individuals
in a
nonprofit organization. So when you see that posting and you see what they're paying, then you should know what you can expect to be paid.
Yeah, and that's where DDP got its start, right? And has really enraged a lot of people who I think didn't want that information out there. I think our sector has sort of forgotten that they owe a duty of transparency to the taxpayer, and we've been told that information has been super, super useful, even just to watch the rate of increase that some of the upper level executives are getting, oh, we can't afford to give you a salary bump, you dancers in the second company, but we're going to have one.
You can see the revenue. You can see also on the form the revenues of that company. So that's also helpful information as well.
So it sounds like more information is more power. Go out and look for it. There is some there. You can obviously use DDP's resources and then get together and collaborate, right?
Right. So it's just when you're looking for a job, you're not just looking for information about that company and what you should do to impress that company, what they're looking for, but you should also look for what it is your value is. So women, and not just women, but women should look and determine what their worth is. If they're not sure what they should ask for in terms of compensation, then they can do this research to see what the market is for the position that they're applying for and what they're being paid in that position.
That's great. So looking back at younger Jackie, or advice that you would give to women applying for jobs, are there 3, 4, 5 things that is just like must, or really think about? I love the framing it. Think about how you are valued, not just, oh my God, am I going to get this job and I've got to grab it, right?
Right. So you think about, one, what is it that you're worth? Try to understand what you should be asking for in terms of compensation. 2, when you get that job offer document, don't sign it right away. Take time to read it, have an attorney review it. And 3, once the employer starts asking you for certain obligations, such as a non-compete or a non-solicit, again, have an attorney review that to determine whether or not it is in your best interest to sign such a document and what you're going to get in return for signing such a document.
That's great. Do you have any particular stories that make you feel really good about what you do for a living, where you've gone to bat for an employee? We talked a little bit about the fact that it's not just sort of termination, but in some cases, a woman has lagged behind and finally said, this is nonsense, and come to you.
Yes, when I represent employees, there have been instances in which there is an employee who would come and say that I've been routinely denied a promotion time and time again at this particular organization, and they refuse to promote me, and I've had enough and I just want to walk out. And so we would negotiate for that employee an exit package such that that employee would be able to get some compensation, which takes into consideration the back pay for the failure to promote that she should have gotten, and perhaps even trying to negotiate front pay for what she would have been able to get if she continued to work at that company, but was terminated before she was ready to leave.
And sometimes it doesn't even mean the person leaves. I mean, my new friend, she's the first chair flautist of the Boston Symphony Orchestra. The guy sitting next to her was making $69,000 a year more than she was in first chair. And they were like, oh, it's not the same thing, et cetera, et cetera. And she's still there. And she's, you know, she got back pay, she got everything else. So sometimes it's not just, you know, you got to leave. You know, sometimes things can be worked out, which I think is really encouraging.
And that is why the wage transparency law is so helpful too, because it's not just when you, doesn't just apply to the time of hire, but it also applies to whenever there's a promotion or there's a job posting in the workplace for another position that's available. That information, if it's advertised and posted, it has to include the salary range such that the employee that's applying for the position could know what he or she should be paid for that job.
Which is why those transparency laws, I think, are just so important, and we're so focused on it. Jacqueline Gerrald, thank you so much. You have done a huge service to the field. I've learned a lot, and I used to do this for a living decades ago. Thank you very, very much. We really appreciate your expertise and your time.
Thank you. My pleasure.